Hi, everyone. It's a pleasure to be here and to see you all today, and welcome to those of you who are joining us online. The continued viability of the death penalty is an important topic, and I want to thank the Washington State Bar Association for hosting a forum on this important issue. As Kevin mentioned, I've been asked to discuss the problem of disproportionate impacts in the death penalty. In other words, the unfair application of the death penalty. Because when it comes to the death penalty, we can have a lot of disagreements about whether the death penalty is a good idea in theory, right? There are a lot of debates. For example, people on one end of the spectrum say, an eye for an eye. If you kill, you deserve to die. And at the other end of the spectrum, people say, an eye for an eye only makes the whole world blind, and the government should not be in the business of killing, right? And the WSBA has made clear that it does not take a position in that debate. And I'm not here to take a position in that debate, frankly, because that debate presupposes that we are capable of selecting the worst of the worst offenders, imposing the death penalty on all of them, and not imposing it on anybody else. And frankly, that is just not what happens in the real world. In the real world, what happens is that we impose the death penalty on a tiny random subset of the worst offenders, and that's obviously unfair. And then to the extent that the imposition of the death penalty is not random, it turns out that we impose it in a very racially biased manner, and that also is unfair. So no matter your political persuasion, no matter your position in that theoretical debate, nobody wants a death penalty that is imposed disproportionately, that is imposed unfairly. And frankly, even if they did, that type of system is unconstitutional, as we'll discuss today. So I'll start by giving a little bit of background about what exactly the problem is, and then we'll talk about what solutions have been attempted. Spoiler alert, those solutions failed. And then we'll talk about what the future might hold in this area, okay? So the overarching problem that we're dealing with here is too much discretion. There's a lot of discretion given to decision makers at every step of this process, and that leads to unfair outcomes. So the discretion I'm talking about is, for example, prosecutors have a great deal of discretion in determining what crime to charge when there's a homicide. Do they charge manslaughter or second-degree murder or first-degree murder, none of which have the death penalty as an available option? Or do they charge aggravated murder, for which the death penalty is available? Then at the next step, even when they have charged aggravated murder, they have a lot of discretion in determining whether to seek the death penalty or whether to seek only life without the possibility of parole. And then finally, for those cases where the prosecutor has decided to seek the death penalty, juries have a great deal of discretion in deciding whether the defendant before them should be sentenced to death or should instead be sentenced to life without the possibility of parole. And what happens when you have all this discretion is that it leaves room for arbitrary decision-making, and it leaves room for the play of racial prejudices, both conscious and unconscious. And this is a problem that the U.S. Supreme Court recognized over 40 years ago. Way back in 1972, in Furman versus Georgia, the U.S. Supreme Court struck down the death penalty statutes that existed at that time because of this problem. Because of this problem of too much discretion. There's a picture of a lightning bolt on this slide because one of the famous quotes from Furman versus Georgia is something like, being sentenced to death is like being struck by lightning. That's how arbitrary and capricious it is. And what the court said specifically is, look, of all the people convicted of murder, many just as reprehensible as these, the petitioners are among a capriciously selected random handful upon whom the sentence of death has in fact been imposed. And the court said this violates the Eighth Amendment. The Eighth Amendment, of course, prohibits cruel and unusual punishment. And then the other problem with these statutes that have too much discretion is that in some sense the death penalty ends up not being so randomly applied. They said if any basis can be discerned for the selection of these few to be sentenced to die, it is the constitutionally impermissible basis of race. And this is a picture of Mr. Furman on this slide. As you can see, he's African American. And so, as I said, in 1972, the court struck down the death penalty statutes that existed at that time because there was too much discretion, and that discretion resulted in the unfair application of the death penalty. It resulted in the arbitrary and racially biased application of the death penalty. But the court did not say that the death penalty is categorically unconstitutional. You know that because we have a death penalty now, right? So what happened is that states went back to the drawing board, and something like 35 states reenacted the death penalty after Furman versus Georgia, and they tried to fix these problems that the court had identified in Furman. They tried to limit eligibility for the death penalty, in other words, fewer crimes rendered people eligible for the death penalty, and they tried to narrow discretion that prosecutors had and discretion that juries had to impose the death penalty. And one of those statutes, one of those new statutes, was before the court again 4 years later in a case called Gregg versus Georgia. And the Georgia statute did all those things I just mentioned and also provided something called proportionality review, which is where the state Supreme Court reviews a death sentence in a particular case and asks, is this sentence proportionate to the sentences imposed in similar cases? In other words, is this death sentence fair in light of the sentences others are receiving for similar crimes? So the Georgia statute had all of these provisions, and the petitioner in Gregg versus Georgia said to the Supreme Court, hey, court, this new statute is not going to work any better than the statute you struck down in Furman versus Georgia. We're still going to have a death penalty that's arbitrarily and capriciously applied. This is still unconstitutional. And the U.S. Supreme Court rejected that argument. The U.S. Supreme Court said, well, we don't see any evidence that this new statute won't work, and we're willing to assume that it will work, that it will fix those problems in the absence of evidence to the contrary. The court noted that 35 states had reenacted the death penalty after Furman, and the court also noted that the American Law Institute included a death penalty provision in the model penal code that it thought would fix these problems. One of the reasons that the court had struck down the earlier statutes in Furman versus Georgia was because of a report by the American Law Institute outlining all of these problems. And the court said, well, the American Law Institute has this statute in the model penal code. They seem to think that it will work, that it will prevent these problems of arbitrariness and bias. And if they think it'll work, we don't see any evidence that it won't. So off you go. You can get back to the business of executing people. Meanwhile, in Washington, our legislature also reenacted the death penalty. And in Washington, we limit eligibility for the death penalty to first-degree murder with one or more aggravating circumstances. And I won't spend too much time on this because Mark went through it 2 sessions ago. Our legislature also narrows both prosecutorial and jury discretion. Prosecutors cannot seek the death penalty unless they have reason to believe there are not sufficient mitigating circumstances to merit leniency. And then juries cannot impose the death penalty unless they find unanimously and beyond a reasonable doubt that there are not sufficient mitigating circumstances to merit leniency. So that sounds pretty good, right? That's limiting discretion, that's answering the call of Furman versus Georgia. And what the U.S. Supreme Court said in Gregg versus Georgia is this. They said, if eligibility for the death penalty is truly limited and discretion is truly narrowed so that the penalty is limited to the worst of the worst, then what we would expect is that most people in here who are eligible for the death penalty would receive it, and there just wouldn't be room for arbitrary decision-making, and there wouldn't be room for the play of racial prejudices. Okay, so that was the idea. And then Washington also provides proportionality review, which again is where the state Supreme Court reviews a death sentence and asks, is this sentence proportionate in light of the sentences everyone else is receiving for aggravated murder? Okay, so those were the solutions that were attempted. Now, it didn't work, Here in Washington, for example, we started out with 10 aggravating circumstances, and now we're up to 14. And as Mark indicated earlier, that's actually a severe undercount because each of these aggravating circumstances has subsections. So we have something like 30-something aggravating circumstances, really. And each of these aggravators has been interpreted broadly. So eligibility for the death penalty is really not that limited. And Washington's not the only state with these problems. Every state has these problems. There was a major study out of Colorado a few years ago, for example, that concluded that in light of the number and breadth of their aggravating circumstances, just about any homicide could be characterized as a capital case and could be charged as capital murder. So that really didn't work very well. Another thing that didn't work was proportionality review. First of all, in 1984, the U.S. Supreme Court held that proportionality review is not constitutionally required. The court in Gregg versus Georgia had noted that provision with approval, but they never said that it was a constitutional prerequisite. And then in Pulley versus Harris, they said it's not. So several states removed that protection from their statutes. A lot of states kept it. Washington state still has that provision, for example. However, the Washington Supreme Court has never reversed a death sentence pursuant to its statutory proportionality review. Okay? And then, in 1987, the U.S. Supreme Court rejected statistics demonstrating racial bias. They said that that's not good enough to show a violation of the 8th or 14th Amendments, and that was in a case called McCleskey versus Kemp. Now, McCleskey technically was only an as-applied challenge, meaning that the holding only applied to that defendant, and the court was careful to say that it was not rejecting a systemic challenge to the death penalty. So that argument is still available. However, it was still a very disappointing decision. It was a 5-4 decision. And what the argument was this. Mr. McCleskey presented to the court the results of a statistical analysis of Georgia's capital sentencing scheme. And that analysis was performed by Professor Baldus. He controlled for 39 variables that are supposed to matter in making the sentencing determination. And what he found was that defendants who killed white victims were more than 4 times more likely to be sentenced to death than defendants who killed black victims. And then also, black defendants were slightly more likely to be sentenced to death than white defendants. And so Mr. McCleskey took this information to the court and essentially said, okay, well, in Gregg versus Georgia, you guys said that you didn't see any evidence that this wouldn't work. Now here you go. Here's the evidence that these statutes did not fix the problems that you identified in Furman. The death penalty is still being imposed in a disproportionate, discriminatory manner, and therefore you should reverse my sentence. And as I mentioned, the Supreme Court disagreed in a 5-4 decision written by Justice Powell. He said, we hold that the Baldus study does not demonstrate a constitutionally significant risk of racial bias affecting the Georgia capital sentencing process. That is a picture of Justice Powell right there. Now, a few years later, maybe even just a couple years later, Justice Powell retired, and his biographer asked him if he had any regrets from his 15 years on the court and hundreds of cases he'd worked on. And Justice Powell said, only one, McCleskey versus Kemp. Okay, and so that was great that he acknowledged that mistake. Oftentimes people don't acknowledge mistakes, but it was too little too late. You know, you have to have the courage to do the right thing when it matters. You have to have the courage to do the right thing when it matters. Meanwhile, let's flip back to what's been going on in Washington. And in Washington, unfortunately, the data show that we have not been any more successful than anyone else at preventing these problems of arbitrariness and racial bias, even though our legislature tried. Our legislature put in those statutory safeguards that tried to limit discretion to the degree necessary to avoid unfair outcomes. But unfortunately, it hasn't worked. So what we've ended up with in Washington is a situation where since 1981, approximately 300 adults have been convicted of aggravated murder and sentenced to life in prison. Only 5 have been executed, and only 8 are on death row. Now, at first, that looks really good, right? I mean, we have a small number of people on death row, so it looks like we're being really careful in the imposition of the death penalty. But the problem is that those 13 are not the so-called worst of the worst. Those 13 are not worse than the 300 who ended up with life sentences. If you read through the facts of these 300 cases, and they're horrific, and I have read through all of them, and Mark has read through all of them, and only a handful of people in Washington have done this. I wouldn't recommend it necessarily, because it's awful. But if you read through all 300 of these cases, you will not in a million years understand why those 13 people ended up with death sentences and everyone else did not. So that's the problem that we're seeing here. And what the U.S. Supreme Court said in Furman versus Georgia is this. They said a capital sentencing scheme violates the Eighth Amendment if the death penalty is exacted with great infrequency, even for the most atrocious crimes, and there is no meaningful basis for distinguishing the few cases in which it is imposed from the many cases in which it is not. And that's what you see going on here, okay? That is one of the reasons that our governor issued a moratorium 3 or 4 years ago. He said equal justice under the law is the state's primary responsibility, and I'm not convinced that equal justice is being served. He said it just doesn't seem fair that these people are on death row in light of all of these other people who are not. And let me just explain a little bit more about who is and is not on death row. A few of the people on Washington's death row committed aggravated murder against one victim. But 101 people in Washington who committed aggravated murder, that's the worst kind of murder, against multiple victims are serving life sentences. And it's not as if those murders were quick and painless. Unfortunately, most of these multiple victim aggravated murders, just like most of the single victim aggravated murders, involved extreme cruelty and unspeakable victim suffering, yet all of these people are serving life sentences while this handful of others is on death row. And our governor's not the only one who's recognized this unfairness. 10 years ago, Justice Johnson of our state Supreme Court wrote for 4 dissenters in saying that he would have held that Washington state's death penalty is unconstitutionally arbitrary. That was in State versus Cross. He said, the death penalty is like lightning, quoting Furman, of course. And he said, when we don't impose the death penalty on Washington's worst mass murderers, then on what basis do we determine on whom it is imposed? Now, Justice Johnson also lamented that Washington state's statutory proportionality review had become an empty exercise, and he would have reversed Mr. Cross's sentence under that provision as well. 4 years ago, Justice Fairhurst said something similar in writing for 3 dissenters in State versus Davis. Justice Fairhurst said, you can't predict in Washington who's going to get the death penalty and who's going to get life in prison. You can't predict it based on the crime. You can't predict it based on the aggravating circumstances. You can't predict it based on the defendant's criminal history. You can't predict it based on his personal history. She said you may as well flip a coin to decide who gets the death penalty and who gets life in prison. And that's not fair. And like Justice Johnson before her, Justice Fairhurst lamented the fact that their proportionality review had become an empty exercise. She would have reversed Mr. Davis's sentence under that provision as well. Also in Davis, Justice Wiggins wrote his own dissent. Somebody's smiling at the picture. I hope these pictures are okay. They're recent pictures that all of these folks have on the course website, so they have to be happy with them. Justice Wiggins wrote his own dissent, and he said, I agree with Justice Fairhurst that we have a big problem with the death penalty being imposed arbitrarily and randomly, but he said, in some respects, it might not be so random. He said, it seems to me that African Americans are more likely to be sentenced to death than Caucasian defendants. And he viewed that as a problem that the court should address pursuant to its statutory proportionality review. It's also a constitutional problem. But Justice Wiggins noted that that court had frequently described one of the purposes of proportionality review as being sure to prevent race discrimination from pervading the imposition of capital punishment in Washington. Now, another thing that Justice Wiggins emphasized in his dissent in Davis was this. He emphasized that he was not accusing anyone of deliberate differential treatment. He was willing to assume that no juror was purposely choosing to sentence a black defendant to death because he was black, and no juror was purposely choosing to sentence a white defendant to life because he was white. He was willing to assume that most of this or all of this was a result of unconscious bias. And we all have unconscious biases, right? But he said, look, it doesn't matter whether this is conscious or unconscious, because if African Americans are in fact more likely to be sentenced to death because of their race, then that is unacceptable. And so Justice Wiggins in Davis would have remanded that case to the trial court to take evidence on the statistical significance of this apparent disparity. Now, of course, that didn't happen because this was a dissent. So what Justice Wiggins was really doing was issuing a call to action for future cases. And as it happened, about a month after that opinion, Neil Fox and I were appointed to represent Alan Gregory on appeal from his death sentence. This is a picture of Mr. Gregory. He's obviously African American. And he was sentenced to death for the aggravated murder of one white woman in Pierce County, Washington. He was only 24 years old at the time of the crime. Now, you would think that since he's one of those only 8 people on death row, since he's one of those only 8 people on death row, despite having a single victim crime and being relatively young at the time, you would think, well, he must have a really heinous criminal history that would justify his place on death row. But you would be wrong, because his only prior felony was theft of a skateboard when he was 13 years old. And meanwhile, scores of other defendants with very violent felony histories, plus 1 or more aggravated murders, are serving life sentences, okay? So one of the first things that we did was to answer Justice Wiggins' call to action and commission a statistical study of Washington's aggravated murder cases. That study was performed by Professor Catherine Beckett and graduate student Heather Evans at the University of Washington. We chose Professor Beckett because she's a nationally respected social scientist, and she's also very well regarded here in Washington State. She was one of the lead authors of that 2011 report on race and Washington's criminal justice system. She's an elected member of the Washington Academy of Sciences. Heather Evans is also outstanding, and she's an expert in quantitative analysis. So the data set that they used in their study is the same data set that our Supreme Court uses for proportionality review. And again, the trial judge reports is something that Mark mentioned a couple sessions ago. But just to reiterate, at the end of each aggravated murder case in the trial court, whether it's a life case or a death case, the trial judge is required to fill out a form with a lot of fields dictated by the legislature with information about the crime and the defendant. And then those are filed with the Supreme Court and used for proportionality review. So that was the data set that they used. They took it, they performed a regression analysis. Don't worry about this picture, it's just a picture of regression output. But before they even did that, before they did anything fancy whatsoever, they just did the same thing that Justice Wiggins had done, which is to look at the straight percentages. And they noted that in Washington, more than 60% of African American defendants who are subjected to a capital sentencing proceeding are sentenced to death by juries, but less than 40% of white defendants who are subjected to capital sentencing proceedings are sentenced to death. And so what I'm talking about here is all of these people are people for whom the prosecutor has decided that the death penalty should be imposed. The prosecutor has sought death for all of these people, but juries impose the death penalty for more than 60% of African American defendants and less than 40% of white defendants. And that's obviously a huge disparity. So the question becomes, well, is that disparity due to race, or is it due to case characteristics? I mean, do African American defendants just commit more heinous crimes, or what's really going on here? So in order to answer that question, the researchers performed a regression analysis in which they controlled for the case characteristics that are supposed to matter. Things like number of victims, aggravating circumstances, mitigating circumstances, criminal history, even victim suffering. And what they found is that most of the variation in sentencing cannot be explained by the relevant case characteristics. Some of those case characteristics were found to have no impact at all, even though they should. Others had some impact, but they didn't come close to explaining most of the variation in sentencing, which goes to show that there is arbitrariness in capital sentencing. But the other thing that the regression analysis showed is that African Americans are more than 4 times more likely to be sentenced to death than other defendants, after controlling for the case characteristics that are supposed to matter. And that's obviously untenable. Now, Pierce County hired a professor to critique that study, and he issued a critique saying that he could not replicate these results. But Professor Beckett and Ms. Evans wrote a reply explaining that this critic had made a couple of major errors that resulted in dropping a significant number of cases from the analysis. And so when you correct those errors and restore the full data set, what you find and what they concluded is that there is strong, consistent, and compelling evidence that jury decision-making in in capital cases in Washington state has been notably influenced by the race of the defendant. Okay? And so on that basis, in Mr. Gregory's case, we have argued that our Supreme Court should hold that the death penalty as applied is unconstitutional. These pictures, the middle one's the Eighth Amendment. The one on the far side is a picture of our state constitution. For those of you who don't know, Washington state has a very strong constitution. It's stronger in many respects than the federal constitution. So we have asked our Supreme Court to hold that the death penalty is unconstitutional, in part because of this problem of disproportionality. Now, that case is still pending. It takes the court a very long time to decide capital cases because there's so much material to read. So we actually argued it over a year ago, but the court has voluminous briefing to read and also has to wade through these statistical studies before deciding the case. In the meantime, to close this out, I'm going to flip back to what's going on nationally in recent years. First of all, since Gregg versus Georgia, 9 states have repealed the death penalty. So we now have 19 states without it. Nebraska, of course, flipped back and forth, so they're not included in this list. But 9 states have repealed it, and some of these states, one of the reasons that these states have been repealing the death penalty is because of this problem of unfairness, this problem of disproportionality. The New Mexico governor, in signing their bill into law, noted that minorities are overrepresented on death row. And the Illinois governor, in signing their bill into law, noted the problem of discriminatory treatment. Another thing that has happened recently is that several governors have issued moratoria. We obviously talked about our Governor Inslee issuing a moratorium, but governors of Oregon, Colorado, and Pennsylvania have also done so. And they've done so in part because of this problem. So the Oregon governor said that the death penalty is not equally applied to all. The Colorado governor said the death penalty is arbitrarily sought and imposed. And even when you take into account the heinousness of the crime, it appears that race and geography are significant predictors of who gets the death penalty. And he said that's not justice. Some other big things that happened recently. First of all, in 2009, the American Law Institute withdrew the death penalty from the Model Penal Code. Now, that is very, very significant because, as we discussed earlier, the United States Supreme Court has always relied in part on the judgment of the American Law Institute in its major capital cases. It relied on the judgment of the ALI in striking down the death penalty in Furman, and it relied on the judgment of the ALI in upholding the death penalty in Gregg versus Georgia and McCleskey versus Kemp. But now the American Law Institute has concluded that no state has successfully limited the death penalty to a narrow band of the most aggravated cases, that no state has solved these problems of arbitrariness and racial bias in the death penalty. And so the ALI threw in the towel in 2009 and withdrew that statute from the Model Penal Code, which is, again, very significant. In 2015, there were a couple of very significant developments in the courts. First of all, the Connecticut Supreme Court struck down the death penalty under their state constitution because of these intractable problems of arbitrariness and racial bias. That was in State versus Santiago. Now, it's a little more complicated than that because the Connecticut legislature had repealed the death penalty, but they'd done so only prospectively. They still wanted to execute the people they already had on death row, and the Connecticut Supreme Court said, no, you can't do that. If you're going to repeal it, you have to repeal it for everyone. But the reasoning of their opinion made clear that it was not limited to this partial abolition problem. Rather, the Connecticut Supreme Court believed that as a general matter, the death penalty is unconstitutional because of these problems of arbitrariness and racial bias. The court said, the selection of which offenders live and which offenders die appears to be inescapably tainted by caprice and bias. And then two concurring justices wrote separately to underscore the problem of race discrimination. They said, historical accounts of persistent racial disparities in capital sentencing have been borne out repeatedly by contemporary statistical evidence. Then, also in 2015, and actually this was just a little bit before Santiago, Justice Breyer, joined by Justice Ginsburg, wrote an important dissent in a case called Glossip versus Gross, in which he said we need to reevaluate this proportionality problem because I think it still exists. Now, Glossip, and one thing that actually makes this dissent so important is that Glossip wasn't about proportionality. Glossip versus Gross was actually a challenge to the method of execution because the Eighth Amendment prohibits not just disproportionate punishment, but also punishments that carry too great a risk of substantial suffering. So in Glossip, the issue before the court was whether a particular drug that's used in the three-drug lethal injection protocol violated the Eighth Amendment because it carried too great a risk of substantial suffering. The Supreme Court rejected the petitioner's argument in a 5-4 decision. Justice Sotomayor wrote the principal dissent on that issue for 4 justices, but as I mentioned, Justice Breyer wrote his own dissent, joined by Justice Ginsburg, in which he said, guys, we shouldn't even be answering these little procedural questions. It's time to step back and reevaluate the proportionality problem because it seems to me, and he was reviewing all sorts of data, that the death penalty is not imposed based on the egregiousness of the crime. If anything, it's imposed based on race and geography. So what he said is in 1976, he's referring to Gregg versus Georgia there. In 1976, the court thought that the constitutional infirmities in the death penalty could be healed. Almost 40 years of studies, surveys, and experience strongly indicate, however, that this effort has failed. And so what Justice Breyer, joined by Justice Ginsburg, was doing there was issuing a call to action to courts all around the country to reevaluate this proportionality question, to reevaluate whether the death penalty is unconstitutional because of these problems of arbitrariness, racial bias, and disproportionate impact. And that's, of course, what we're asking our court to do. And armed with this information, you can perhaps have reevaluate the issue for yourself and have some good conversations with each other, which I think is what the WSBA is hoping to foster. But I'm going to turn it over to Mark now, who's going to talk more specifically about county-by-county disparities.
One of the things that Justice Breyer mentioned in the Glossip, his Glossip opinion, was that one of the things he was looking at is also geographic disparity, and he was looking obviously at national levels and saying what states that do have the death penalty, is there some geographical disparity amongst those states, for example, within the counties of those states, And so one of those, and it's a factor that he was looking at about disproportionate regarding kind of geographic location, or perhaps that's redundant, geographic, where death is being sought or imposed geographically. What I want to show you is how that looks in Washington State over the last 40 years. And I think there's really two things to take from here. One is, as I mentioned, I don't recall if it was last week or the week before, part of the Eighth Amendment analysis, the cruel and unusual, or in Washington, is the cruel provision of the Washington State's Constitution, is we look at things to determine what the evolving standards of decency. And I think I talked about that when the courts, at least the Supreme Court looks at it, they often will look at what are jurisdictions doing. And I think I used the example of juveniles and intellectual disability when they were looking at Washington State to determine whether juveniles or individuals with intellectual disability should be barred from execution. And that's kind of, they were looking at the various states to determine the evolving standards of decency. So we look for that for trends. So that's the one thing I think we should look at in this overarching review of Washington's death penalty by geographic disparity. The second is just that, geographic disparity. There was a case that you may be familiar with in around 2000, Bush versus Gore, dealing with the Chads in Florida. And part of that, and I'm not here to talk about that case specifically or in any great detail, but one of the things that they were looking at or they were concerned about was county by county counting of the Chads, of the election. And so in Washington State, something similar sort of happens. And what I mean by that is there's 39 counties. And as we talked a week ago or 2 weeks ago, each elected prosecutor gets to decide whether he or she is going to seek the death penalty. There are no real statewide standards. There's a statute that basically says it's up to the elected prosecutor to decide. There's some kind of squishy guidelines, but in essence, it's each elected prosecutor. So there has been some challenges legally, kind of under the Bush v. Gore kind of a concept. But this is from 1981, as you know, that's when Washington's death penalty statute was enacted, to 1985. And I got to tell you, there was no rhyme or reason when we chose every 5 years. I don't know why we did that, but I think it was just made kind of numerical sense at the time. So this is every 5 years. And as you'll see, out of the 39 counties, only a handful have sought the death penalty. The death was sought 24 times, and it was imposed in 8. And what you'll see, for at least for the next 3 or 4 slides, is that death was sought and imposed primarily in the 4 larger counties of the state, Spokane, Snohomish, King, and Pierce. And to some extent that makes sense, I think, just population-wise, cost-wise. These are the counties that, at least in theory, could perhaps afford it. As we mentioned, if it's a trial case, it's the county where the case is being charged and tried as the county in which the cost is bared. So in 1981-85, you'll see 24 death penalties sought, 8 imposed. In 1986 to 1990, it's dropping down to 21 sought, 5 imposed. The counties, as you'll see, are getting smaller than those that are seek it. But as you still will see, at least in Pierce and King, are primarily where it's being sought, and in particular Pierce. 1991 to 95, it's dropped even dramatically to death penalties being sought 14. A couple of new counties, or at least more recent counties, I guess at that point, have sought, but still death penalty is imposed 9 times. And again, Pierce and King and Snohomish and Spokane are kind of leading the way. And I don't have a chart for this, but I could tell you that it was, when we studied it, at least back in 2004, we were looking at the 4 counties, the larger counties, and there was and you can probably sort of glean it from these slides, but there was a wide variety of discrepancies within the 4 counties themselves. 1996 to 2000, dropping down to 17, and sought and 7 imposed. But here's where we start seeing the dramatic change. 2001, only 3 counties, 3 death penalties sought, 1 imposed. And I don't know, people have asked me, why do I think, or do I have an opinion about why all of a sudden in 2000 did it change? And I can only speculate. And one of the speculations that I have, or at least the hypotheses or theories that I have, a couple of things changed during that time. We've touched on them a little bit throughout the last 3 weeks. One was the Washington Supreme Court adopted a rule that required qualified counsel to take over capital cases. Now, I'm not suggesting just because there's qualified counsel that was an immediate reason for a direct reason for the dropping of death penalties being sought, but at the same time or shortly thereafter, there was a significant case called Wiggins from the United States Supreme Court that required counsel, or at least laid out the framework what death attorneys needed to do pertaining to investigating mitigation, and we talked about that. Last week, I think Bob was mentioning about one of the factors that has led to some of this cost. And it's a wide net of information that is needed dealing with the defendant about his or her background. And I think, again, this is my own hypothesis, but I think this was a factor that has led to some of these drops. Because what typically will happen is this collecting of this information, and it goes deep, as they say, 3 generations deep of the individual. And as Mark Larson talked about 2 weeks ago, as a prosecutor, they often will obtain that information, digest that information, and determine whether death is the appropriate sentence or not. So I think there was a perfect storm, so to speak, where you had a requirement of qualified counsel. You had a United States Supreme Court case that required a wide range of mitigation being investigated, and so there was more information about the individual that was being brought to the prosecution. Again, that is purely speculation on my part, but I do think that there was some of significance of those events. 2006 to 2010, only 1 county, the death penalty was sought, and it was imposed. A little bit of a click up from 2011 to 2014, 2 counties, and both times it was sought and both times it was imposed. And as we talked about over the weeks, those are currently on appeal. But at a minimum, you'll see when we started back in the earlier slides, there was a lot of yellow and red. I think the other color was yellow throughout the state. And as you see this arching trend, what I would say an evolving standards of decency trend, to just recently only 2 counties in which it's being sought or imposed. 2014 to 2016. There's been 2 cases. Let me explain this. There's been actually 3 cases in which death was initially sought. All 3 were in King County. One of the cases had 2 individuals, 2 co-defendants. One of those co-defendants went to trial. The jury came back for a life sentence. The prosecutor then withdrew the death notice on the second co-defendant, basically, in essence, saying it wouldn't be just or fair to try to have a jury sentence this individual to death when the co-defendant did not get the sentence of death, or they couldn't prove it beyond a reasonable doubt to the jury. The other gentleman was charged with killing an officer, and he was convicted. And a jury, I think if I recall correctly, was within the hour, and it was unanimous, came back with a life sentence. So you'll see, and as of now, as far as I know, and I'm pretty accurate about this, is that there's not a current case in Washington State where death is being sought at the trial level. And so what this has shown us is when we look at the evolving standards, not only geographic disparity about the counties in which it's being sought, but also this kind of evolving standards concept that the counties are diminishing. We look at a couple of things. Is it being sought by the prosecutor? And you'll see the trend has been that it's been moved away from being sought by the prosecution. And also are juries imposing it? And if you go back and look at the slides, the jury has diminished imposing it over the years. And as I mentioned, just recently in the last handful of years, when it was being sought in King County, they did not impose it. The other, as you may recall last week, I think it was Bob or Peter were talking about the cost of those cases in King County, and they were reaching up to $15 million for roughly 3 cases. And as I noted, 0 of them netted a death sentence, which means they're all getting life without the possibility of parole. This is, and you saw this slide last week. I think Peter presented it, but this is more of kind of a broader scope by decade, and it's just consistent with the the 5-year slides that I was showing, that the death penalty cases being sought over the decades has dropped tremendously. I don't know, again, what the end result or why that is. I have a handful of ideas. I think one is, like I said, qualified counsel, what's required of qualified counsel, and I think the byproduct of that also is cost. I think the public is getting more knowledgeable about the death penalty, are questioning it, and those are, in fact, jurors, obviously, that are sitting in on these cases, although they're quote-unquote death qualified, meaning that they believe in the death penalty to some degree. I think in reality they are, at least in the last 10 years, have moved away from it. I think innocent, wrongfully convicted folks is leading to some of the acknowledgement or the understanding about the death penalty. But at the end of the day, in 40 years, we have seen a dramatic decline, yet an increase in reversals, a dramatic decline in the prosecutors seeking it and the juries imposing it. I'm going to stop, and I think we'll open up to questions.
Hi, this question is for Lila. You gave us statistics for the percentage based on race of the jury imposing the death penalty when sought and sort of likelihood of getting the death penalty for aggravated murder. Do you have statistics based on race for the prosecution seeking the death penalty?
Those are in the report. I don't know that I have them at my fingertips. But what the researchers found is they actually did not find a racial disparity at that stage. So at the stage where prosecutors are seeking the death penalty, they didn't find any statistically significant disparity one way or the other. It was at the jury stage that they found that race mattered and mattered a lot.
I appreciate that. This is an outstanding presentation. So you know where I'm coming from. I served as the United States Attorney for Eastern Washington under Presidents Bush and President Obama, and I currently serve as Vice Chair of Governor Inslee's Clemency and Pardons Board. So this is very, very relevant. Don't take this as a criticism. I didn't participate in the first 2. But one thing I would have liked to seen is maybe a prosecutor on the panel or someone, to, not that your view isn't balanced, it's outstanding. As I said, both of you know your material. But in an issue that's as important as this is, and that has failed, the repeal has failed to get through the legislature, et cetera, I think that it would have been helpful, at least from my perspective, to listen to to someone from the prosecution.
Okay, thank you for that feedback. I'm sure the WSBA will take it very seriously. I can tell you, if you want to see both sides, you're welcome to go to tvw.org and watch the oral argument in State versus Gregory. It was on February 25th of 2016, so you can easily search for it at tvw.org, and you will see both sides presented, and I would encourage you to do that if you're interested in this issue.
If I may, since I have been participating in all 3 sessions, there was a prosecutor at the first week. But also, we have reached out to various prosecutors for each of the weeks, and for a variety of reasons have been unsuccessful. So it's not a lack of attempt, I should say.
You had mentioned that the bias tends to come out in jury cases, but I'm wondering, is the death penalty still used as sort of a bargaining chip in plea bargaining? And so does that somehow affect it downstream in whether or not the prosecutors are willing to put it on the table or not at all?
Right. It's a great question. I could tell you, at least from my experience, that the prosecutors in the state of Washington have, or King County in particular, but I think it's probably across the board, have indicated their unwillingness to use it as a bargaining chip, which I appreciate, because I think it shouldn't be, and they've taken it very serious in not wanting to use it as a tool to try to get a guilty plea. A couple things that potentially are a byproduct of that, though, in those jurisdictions. Not, I don't think it happens in Washington State, but in other jurisdictions where it is. For example, in the state of Oregon, where I have practiced, that has a little bit of this problem. And that is when they use it, when it is used as, the death penalty is used as a bargaining chip, it does often, or can, I should say, lead to wrongful convictions. Because an individual who's, understandably so, fearful of the result of being the death penalty may enter a plea, or enter a plea of a charge that's not of something that he or she may not actually be guilty of. It may not be aggravated murder, for example. It may be a different degree of murder, but it may not be an aggravated murder. But in Washington State, I think, and I'm pretty confident that the elected prosecutors have taken the death penalty decision very, very serious, and do not appear to use it as a tool. In my negotiations on a handful of cases that I've worked on, I've never once had a prosecutor indicate to me, we'll withdraw the death penalty if your client pleads guilty. Now, that often is the result, but it's not the driving, I've never had that as the driving factor presented to me by the prosecution. If there's no further questions, I would like to close this out and want to thank the Washington State Bar Association for putting this on, for the folks who have participated in attendance all 3 weeks or any one of the weeks, and have asked questions. We hope this has been useful, and I believe there are some similar types of seminars in the future that I would highly recommend folks to participate and join. Thank you very much.
Thanks.